In this video, I want to take a look at appeals to the Labour Court and what are the essential things you should know. When can you appeal and how is it conducted? What are the rules and so on? So let's take a look. Firstly, there are two types of appeal to the Labour Court. One is an appeal of a decision of an adjudication officer in the Workplace Relations Commission. So that would be a first instance complaint about unfair dismissal or Organisation of Working Time Act or whatever, discrimination, and you may or may not be happy, or the other party may or may not be happy with the decision of the adjudicating officer, then that decision can be appealed to the Labour Court. There's another type of appeal that can go to the Labour Court, and that is the appeal of by an employer of a compliance notice received from an inspector. That's an inspector from NERA or the Workplace Relations Commission, just perhaps in relation to minimum wage payments or working time records or records that the employer should keep or whatever. They are the two types of appeals to the Labour Court. The division of the Labour Court. Each case is dealt with by what's called a division of the Labour Court. And a division comprises a chairman, an employer member, and an employee member. The time limit for bringing an appeal from the decision of an adjudication officer is 42 days from the date of the decision. So if you want to bring an appeal, make sure you check the date on the decision from the Workplace Relations Commission. Time can be extended, but only in exceptional circumstances. The procedures then in the Labour Court. Well, Labour Court business, unlike WRC business, is conducted in public, and the normal rules are set out in 4 parts as follows. The procedure for appeals of adjudication officer in relation to employment equality and unfair dismissal cases. The procedure for appeals of compliance notices served on employers. The procedure for appeals in respect of other employment enactments, and then the procedure to be followed at the hearing itself. These Labour Court rules, they can be found on the Workplace Relations Commission website, or simply do a simple Google search of Labour Court rules, or indeed visit my website employmentrightsireland.com, and there's an article there or a post there about appealing to the Labour Court, and it actually has a link in the article about the rules to be applied. So if you just go to my website employmentrightsireland.com, do a simple search for Labour Court and you should find the article. So appeals then in relation to unfair dismissal and employment equality. These would be probably the most common appeals. The appeal is commenced by using a standard form and a copy of the adjudication officer decision. 3 weeks later then you must submit your written submission, which is then sent to the respondent, and the respondent then has 3 weeks to file a replying submission. As I say, the time of 42 days within which you must bring your appeal can only be extended in exceptional circumstances. Both parties are required to send in pre-hearing witness statements at least 7 days in advance of the hearing. These statements should state the name of the witness, a summary of the witness's evidence, and copy documents which would be relied upon at the hearing. It's important to understand that the appeal heard by the Labour Court is a de novo appeal. That means that the Labour Court hears the case from scratch and makes its own decision, completely uninfluenced by the original decision of the WRC adjudication officer. So both parties start from scratch and the original decision has no influence on the Labour Court. 7 days in advance of the hearing then you need to send in written submissions, 6 copies of same. So the parties are expected to set out the facts which are agreed on an issue, the legal basis for the submission, the remedy sought in the case of the complainant, and a transcript of the decisions or judgments relied upon. So if you are relying upon a particular case, for example, or a particular piece of legislation as authority for some proposition you're putting forward and which you rely upon, well then you need to have a copy of that ready. In essence, the parties are to set out their case in full and not focus on the original decision of the WRC adjudication officer. The conduct of the hearing then, it commences with the party bearing the burden of proof, reading his submission. The respondent then reads his submission and the parties are invited to comment on the other's submission. Each party then examines and cross-examines each side's witnesses, and the court may have questions for the witnesses. Parties can represent themselves or engage the services of a solicitor or a barrister or HR representative or whoever you choose. Now, I'm going to give you a big fat disclaimer in relation to what I've just said. The conduct of the hearing is, as I've set out on the screen there, as per the rules. However, the chairman of the division sitting in the appeal has enormous discretion as to how the thing is conducted. And quite frankly, it may well happen that you will not get the chance to examine your own witness or cross-examine the other witnesses. And essentially, as I say, the chairman will very much run the show and determine how the thing is to be conducted. The chairman is likely to ask questions, and all members of the division are likely to ask questions of some or all of the people in attendance. That would be the legal representatives and indeed witnesses if necessary. But I have seen situations and indeed have heard complaints from people who have brought appeals to the Labour Court and who felt that they didn't get a fair shake or weren't asked questions or they didn't get to make their case. But as I say, there's a huge amount of discretion with the Labour Court chairman as to how a particular hearing is conducted, and that's the situation. As I say, you can check out the rules that I referred to earlier in this video and you can see exactly how the thing may happen theoretically, but the reality may be different. But the discretion is with the Labour Court chairman and it's set out in law. Appeals then from a determination of the Labour Court can go to the High Court, but on a point of law only, not on a point to do with the facts or the evidence or anything of that nature, to do with a point of law or some mistake perhaps that the Labour Court may have fallen into in hearing the appeal. My name is Terry Gorry, that's me there on the screen, my contact details. I hope you find this video useful. You might give us a thumbs up down below if you do, and you may be interested in subscribing to my YouTube channel.